Good morning, everyone. Thank you so much for joining us today. My name is Cassie Hopkins, and I help coordinate the webinars and events for Hausman Johnson Insurance and the Benefit Services Group. Thank you and good morning. I would like to welcome you to today's webinar, Fiduciary Fitness, Fiduciary Duties and Responsibilities for Your Company's Retirement Plan. A few housekeeping items. This webinar is interactive and will feature a question and answer session. You can type in a question at any time during the webinar, and John, our presenter, will address it during the question and answer portion of the presentation, which will happen at the end. After the webinar is over, there will be a short survey we are hoping you can fill out for us to give us feedback on the webinar and webinar topics you are interested in learning more about. Another item of note is that this webinar is recorded and will be available on the webinar archives section of our website. Each attendee will receive a follow-up email with a link to this recording, as well as a copy of the presentation slides. I would now like to introduce you to today's presenter, John Friar. Since graduating from UW-Whitewater with his BA in finance, John has spent over 10 years working in the financial services industry. He enjoys working in all of the different facets of financial services industry, including 401k plan consulting, wealth management, and a life and disability insurance. John works with both commercial and personal clients to ensure that each of their financial needs are addressed and are managed appropriately. John lives in Middleton with his wife, 2 sons, 2 cats, and dog, and loves every minute of it. Thank you so much for joining us today, John. Welcome.
Hey, good morning, and thanks everyone for being on the call this morning. As we move forward, some of the things that we want to talk about today related to fiduciary duties involve things that a lot of times we kind of forget about, and we want to try to keep this as simple as possible. But again, many times as we've moved forward, and there we go, Cassie, thank you. I think I didn't have control here. Thank you very much. Okay, so as we're looking at, again, moving forward with fiduciary duties, I want to make sure everyone understands, who is a plan fiduciary and describe what those responsibilities are, because they are very serious. And many times individuals are unsure. Are they a fiduciary? Are they not a fiduciary? And, what things do they need to do? What things should they be educated on in order to truly understand those duties? So even though this seems like, yes, we understand this, again, many times a lot of us are unsure of a lot of these conversations. So why do we talk about this? Why has this become such an important conversation that we're having? It really comes back to the benefits of these retirement plans that we're talking about. And as we've talked to many of our clients, and I'm sure as many of you are seeing, this is a big part of attracting and retaining key employees. It's a challenging, hiring and work environment right now, and individuals are looking to these as, differentiators between maybe one job or one company and another company. They provide potential tax deduction for employer contributions. The big part of this is, as the burden of retirement has shifted from the employer onto the employee, that tax earnings and tax deferred benefits are so powerful. And then as we're seeing more and more, employees are looking to their employer for help to prepare for retirement. And these retirement plans are becoming vitally important. So that's why we want to focus on this, is because employees look to this as a very, very important benefit. So what is a fiduciary? And who is not a fiduciary? So if you look at named fiduciaries, each plan must have a named fiduciary, and they're generally identified in the plan document. It may be a plan sponsor, could be officers of the board, could be trustees, members of a management team, and these responsibilities can be shared too. But a fiduciary is an individual or an entity that exercises discretionary control, and that's the key word, is discretionary control over the management of the plan's assets. So a plan may have more than one fiduciary. And an individual serving can have more than just one capacity when they're doing that. But a lot of times, who is not a fiduciary? So anyone who performs ministerial functions does not have the authority to make decisions with respect to plan policies and procedures. So, for example, if you're processing claims forms on behalf of the retirement plan, that is not a fiduciary duty. And so differentiating the two is really important of who has that liability and who does not have that liability from a fiduciary standpoint. So again, if you have discretion over control of the plan, you're taking on that fiduciary role. And we're going to talk about a lot of times there's individuals who do have that discretion and they may not be aware that they are in theory or in fact acting in a fiduciary capacity. So we have, generally what we have is a functional fiduciaries. So it's basically a functional test where there's no expressed appointment or delegation of fiduciary authority, but functionally you're in control or in possession of authority over the plan's management. So again, an example would be a member of the employer's board of directors or board of trustees with power exercise, discretion or control. So a lot of times we'll hear individuals say, hey, we're going back to our board, they're going to vote on a decision. And in theory, that board may not realize they're having fiduciary function, but they're acting in that capacity because they are having control over that. Even though they may not be named, in theory, they are. So if we look, basically, what are some fiduciary duties? Implementing plan-related decisions. So when you're implementing a fund change or you're implementing a automatic enrollment, the implementation is a fiduciary act. Carrying out the processes and procedures regarding plan management, making sure notices are going out, all of those things, fiduciary act. The selection of a provider, so that would be like the record keeper that you're using, the investments or the investment manager. Those are all, again, fiduciary duties for an individual. Now, what would not be, and this is a lot of times a question we get, is the decision to establish a plan is not a fiduciary duty. Or if you're terminating a plan, a lot of times we work with individuals and say, well, am I breaching a fiduciary duty by taking this benefit away? There's still the difference between making organizational decisions with inside of your fiduciary responsibilities, including plan features. So we talked about auto enroll. Adding that as a feature is not a fiduciary act, but the implementation and making sure that it's done correctly, that is a fiduciary duty or act that it must be carried out. And quite frankly, if you have questions on that, we say, hey, talk to us. Because again, if you think you're acting in a fiduciary capacity and you don't feel comfortable with that, we want to make sure that you're understanding where that line is drawn and who should or should not be making those decisions. So as we're looking at this, we have co-fiduciaries. And co-fiduciaries generally help share and delegate some of those responsibilities. You probably heard of this a lot. A board of directors or a board of trustee can be co-fiduciaries where they're all acting in that capacity. If you delegate authority, responsibility, liability is limited to the selection and retention of fiduciaries unless an individual becomes liable under co-fiduciary rules. You also must monitor the performance of your co-fiduciaries. And we'll talk more about this, but in general, making sure everyone who's listed on there is a fiduciary at that point. Benefit investment committees. A lot of groups have committees where they're acting together as a group to come up and make decisions. So the best practice in that case is probably to have everyone acknowledge that they're becoming a fiduciary. That's one thing that we're talking about more and more, is making sure we're doing that. But also then again, providing education to those individuals, acknowledging what is your fiduciary duty? Because as a fiduciary, you can be both civilly responsible under ERISA and the Department of Labor. So again, there's big responsibilities for individuals when you're looking at this as a designation that you may or may not have within your organization. And you see written meeting notes should be issued about the action taken. We'll talk a little bit more about this in a little bit. But again, it always comes back to document, document, document as we're moving forward. Trustees as fiduciaries. So trustees are fiduciaries due to the management and control of plan assets. So with a lot of plans, when you're setting it up, the trustees who are signing that plan document, they're almost always the fiduciaries to the plan. But again, we can have more than that. You can also hire what's called a directed trustee, which is maybe where you're hiring the record keeper to be the trustee for the plan. But at the end of the day, it's hard to eliminate that fiduciary responsibility, because at the end of the day, that trustee, that directed trustee, still takes direction from you, or takes direction from the organization, or that individual at your firm who has that authority. So again, it's important to monitor those decisions, but ultimately document how and why you're making those selections. And again, a trustee, they can resign to their fiduciary breach of another trustee. So again, that's where the documentation is important as we move forward. Investment managers and investment advisors. So as we're looking at this, for example, myself as an investment advisor, we typically serve in what's called a co-fiduciary role as a 321 fiduciary. And what does that mean is we serve as an investment expert providing investment recommendations. We provide investment advice for a fee. And as we're doing that, we're taking on that liability, say, hey, we're going to provide this advice, we're being paid, but we have a liability to do what's in the best interest for the plan and their participants. And so again, that co-fiduciary role helps share that responsibility with the organization. And we're taking on a portion of that responsibility. Below, you see investment managers section, or ERISA section 338. That's another type of fiduciary mitigation where, for example, an advisor will say, we're going to take on the full responsibility of the investment selection, meaning the organization no longer is adopting it. They're outsourcing that to an investment manager to make those decisions. So if a fund needs to be replaced or added, that investment manager or advisor has the ability to do that without needing approval from the organization. So some firms like that. Some organizations still like having a 321 where the investment manager, again, is making that recommendation, but now the group is making that decision together. In either capacity, the duty of the organization is to still monitor that investment manager or advisor to make sure that they're providing good, sound advice, and that there's a rhyme and a reason for how and why they're making those selections. So as we're in these meetings, that's why you see, documentation. That's why we use an independent process to select and monitor those investments. Because again, the Department of Labor is looking for those things. And in either capacity, 321 or 338, there's still a duty again to monitor that. And again, most organizations still like the idea of being involved to some extent with that decision making, knowing that there's a process in place to select. If you have questions about the difference on that, please let me know. We're happy to go through that in more detail or help figure out which may be most appropriate for your current situation. But in either capacity, you should have a fiduciary hired to help you make these decisions as we're moving forward. A lot of times, you might work with an attorney, your accountant, actuaries, consultants, and your employees. Generally, these professionals performing these functions are not fiduciaries. They can, though, however, if they start providing any type of discretionary authority or control over the plan, and if they're being paid for services that we've talked about. So if they're providing fiduciary advice that warrants it to be fiduciary advice and they're being paid, they've now potentially become a fiduciary to the plan. A lot of these functions, though, are ministerial in nature and they're not going to be. But again, that could happen. And generally, employees are not fiduciaries, but they can, because sometimes they will be on a investment committee where potentially they have discretion to dictate whether an investment should be there, a decision that is made. In a lot of cases, though, they may not have that authority, but again, we should be acknowledging, do they, and are they understanding that they are a fiduciary? There's a few individuals who are prohibited from this role, and in the almost 15 years I've been working on plans, I've never seen this come up. But again, it's something to keep in mind that there are individuals who can be prohibited from being fiduciaries. What I don't know is I'm not sure who's tracking this and looking for this. But again, these are things that when you're setting the plan up, not everyone can just automatically be a fiduciary. So just keep that in mind as you're going forward. So ERISA Section 404A, you have a duty of loyalty. And again, this is something that we should all be doing, but a fiduciary must act solely in the interest of plan participants, their beneficiaries, or any alternative payees. So in doing so, fiduciary must carry out their duties prudently. They must follow the terms of the plan document unless it's inconsistent with ERISA. Diversify plan assets, pay only fair and reasonable expenses. If you've been a part of any of our investment reviews, a lot of times what do? We review the plan document. We make sure that the organization understands how that plan is set up, and so that they're acting or they're implementing the plan document to the best of their ability. Diversifying plan assets, we'll talk about that. And that can be somewhat of a vague term, as what is a diversified plan lineup? But again, as long as you're providing the ability to have an aggressive, a balanced, or a conservative portfolio with different options that are being monitored and reviewed on a periodic basis, you're diversifying your plan, and then paying fair and reasonable expenses, which is why it's very important to benchmark your plan. Every 3 to 4 years, benchmark the fees that you're paying. The Department of Labor and ERISA are not saying you have to have the lowest fees, but simply that they're reasonable. So by doing a benchmark, it's very easy for an advisor, for an organization to see, are we paying reasonable fees, and documenting that. Again, if there's no documentation, it didn't happen. So those are big parts of our reviews that we're always trying to make sure are in place so that our clients understand where they fall in some of these fiduciary functions. So you look at the duty of prudence. When acting on behalf of the plan, have to exercise care, skill, prudence, and diligence that a prudent person familiar with such matters would exercise in similar circumstances. So again, if you potentially don't have the skill to do one of these functions, that's where you might outsource. So a lot of times that's where myself included as an advisor come into organizations. We provide a lot of those services because we have the skill and the expertise in those certain areas to provide that. So if you look, fiduciary's actions are considered prudent if the fiduciary exercises ordinary care based on the facts and circumstances. As long as you're making good, sound decisions that have logic behind them and it's documented, that's really what they're looking for. A lot of the things you'll see where you hear of these big fiduciary litigations, it's where maybe there's been more of a fraud scenario. But again, as long as you're acting in best interest and you have that, they're going to look a little differently on that. So at the bottom, you can see the Department of Labor and the courts measure prudence by analyzing the process used to select an investment or course of action. So maybe when we're looking at plan design and the implementation of that, a lot of times we'll look at, again, what are other organizations of similar size doing? Was there a process for why we removed a certain fund? And that goes a long ways in these processes. There's no group saying you have to make the perfect decision. You just have to make sure you're making a decision that's in the best interest of the plan, their beneficiaries, and that there's a process for how and why that decision is being made. And again, they try to stress that as much as possible as you're going through these different duties that you may or may not have. So appropriate consideration. Determination that a course of action is reasonably designed to further the purposes of the plan. Again, a lot of these are things that are pretty, common things that you generally would think about in any decision that you're making with your organization. With regards to investments, the composition of the portfolios with regard to diversification, liquidity and current return relevant to plans' anticipated cash flows. That a lot of times is if you're having more individuals who are closer to retirement, do you have fixed income options, safer options that are available for those individuals to use? Or if you have a younger workforce, do you have adequate options for more risk-on type investments? And portfolios projected return relative to funding objectives. That is generally a little more related to pension plans, where you're looking to return a certain amount that you need for payouts down the road. One area that seems to have a lot of issues that we see is just following the terms of the plan document. There's a lot of times we go in to do a document review with a new group, and many times what the document says and how the plan's being implemented are really far off. And it's something that we think is a good practice is just go back and review what those steps are every couple of years, just to make sure that are we doing these things. Even your new hire process, reach out to your advisor, reach out to us, and we can help figure out what's the best way to make sure that your organization is following those steps. If you're unaware, always ask. And you should get help to do this because these are important things to follow. So, be familiar with your plan document, your trust documents, your summary plan description, any administrative procedures, how are you making payroll, all of those things. For any of you who have managed a plan, there is a lot of work to go into it, and some of it though can become very streamlined as well, but making sure just that you're aware and reviewing the steps, that goes a long way in making sure that you're meeting those fiduciary duties or that there's not things falling between the cracks. Fortunately for retirement plans, if you're working with a good advisor, they're reviewing fees, they're reviewing the investments, they're helping you figure out processes. You have a third-party administrator who's helping make sure that individuals have received the correct company contributions. If there was missed deferrals, that they're helping you correct that before you go 5, 6, 7 years down the road before you find these mistakes. So mistakes will happen. And I think all the regulatory organizations understand that. But it's when you find those, making sure that you're correcting them and moving forward. Again, as we kind of talk about this from a reporting standpoint, Fiduciaries must comply with ERISA's reporting and disclosure requirements. Delivery systems should result in actual receipt of information to protect confidentiality. A lot of times, some of these the record keepers will take on. The record keepers are becoming more and more involved in a lot of the disclosures that need to go out. They're trying to find more ways to offer value to the client. So that's been, I think, a really good thing. You see there we have a fidelity bond. And if you work with your property casualty insurer, for example, Houseman Johnson Insurance, they offer fidelity bonds. And if you have a retirement plan, you have to have one. The bond must cover at least 10% of the amount handled by the individual. So has to be at least $1,000 up to $500,000. $1 million for plans that hold employer securities. So a good part of this ERISA section 404A is, again, making sure that you have a process. Do an administrative audit, just make sure, are we doing these things? Because some of these, you may not do that often. Maybe it's once or twice a year, and then making sure you have a good fidelity bond in place. I know if you're working with, again, a good property casualty, they're making sure that you have these things. They're talking to you about fiduciary liability insurance and how that can potentially help eliminate claims that may come out of fiduciary missteps. So determining if an individual is a plan fiduciary. You know, we have a guide. So if you have questions on this, please come to us. You know, one of our initiatives over the next, year or so is trying to, again, provide fiduciaries with education so that they are aware of different things that are going on from a fiduciary standpoint. You know, last year there was the Secure Act. We tried to educate as many of our plan sponsors, trustees, fiduciaries on those changes that are going on. Right now, there's plan restatements going out from your third-party administrators, where there's an opportunity to make changes to your plan document if you would so choose to. So there's a lot of things going out there. If you have questions, you can walk through this guide. For example, does the individual have or exercise discretionary authority or control over the management of the plan? Yes or no? Does the individual have or exercise discretionary authority or discretionary responsibility in the administration of the plan? Yes or no? So again, these answers can be very, very easy at times, and many times it's just not asking the question. Is what I'm doing a fiduciary duty, or is it not, because I'm more just processing something in effect? But again, please reach out to us if you have questions on that. And then a few strategies to help minimize fiduciary liability. You can hire an investment advisor. That's the role, for example, myself and Park Capital Management takes on. We work with organizations to help figure out how can we put as many processes, how can we document, how can we create these procedures to help our clients mitigate as much of that liability as we can possibly help with. At the end of the day, as an organization, you still have liability, make sure we're doing what we do. And in meetings, that should be apparent, because you should see the process that's being followed. And typically we follow up with a really nice review of what happened, what decisions were made, and again, that documentation. You can work with lawyers, consultants, administrators. A good third-party administrator is really important as you're looking at making sure that some of the compliance pieces are being met and that they're answering questions. So if you do get into a situation where you do have to make some corrections, a TPA can be very, very helpful. And it's better to make that correction than to wait 3, 4, 5 years, because it only compounds. Just as your investments continue to compound and grow, it's very valuable. The same thing happens if, there's been a miss, and that problem just gets bigger and bigger and bigger. So it's better to take care of it right away. Establish participant-directed accounts. So in general, fiduciaries are not liable for losses due to participant investment choices if they are deemed to be compliant with ERISA Section 404C. We have a lot of different code names that we use, but ERISA Section 404C is something that I know our clients have heard me talk about. If you're providing the ability for, and this is really almost all 401k plans now. In the early going, sometimes you had employer-directed contributions, but for most retirement plans, as long as the participant is able to direct how their investments are made, you've diversified those investments, then you have protections from ERISA Section 404C that if an individual decides to be too aggressive, not aggressive enough, that you have protections against them coming back. Good practices with all of these are, and we'll talk about this, is communication, documentation that you have those things. So one thing, for example, that we do is we send out 4 quarterly education articles, and the articles, may or may not be relevant to every participant, but at the end of it, it's a communication point for you as a plan sponsor, and it's also providing that participant again with contact information to reach out to an advisor or to reach out to a record keeper, that they have a retirement plan and they have the ability to talk to someone if they should have questions. So combining all of those things, can really help protect an organization. And then just doing, again, audits, talking about, are you reviewing your fees? Are you reviewing your plan document? If your organization has questions about, again, new hires or the disclosures that need to go out, is our record keeper doing this? Is this a requirement for ourselves? If you have questions on your 5,500, reach out to your TPA, reach out to your advisor. Those are things that, we want to make sure you feel very, very comfortable with as you move forward. And, we talked a little bit about ERISA Section 404C before, but again, the biggest part of this is fiduciaries do not have an obligation under ERISA to provide investment advice to participants or beneficiaries. So in addition to making sure that you have a broad range of investments to choose from, that an individual can choose their own investments, as a fiduciary, do not feel obligated to provide that advice. Many times we tell our clients, have them call us. Let us be that resource. You're under no, again, obligation to provide that advice. But once you do, again, you're now acting in that fiduciary role. So again, ERISA Section 404C, very, very important to make sure you're following. Again, what is a broad range of investment options? It's a vague term, but again, do you have options for someone to be aggressive as an investor, middle of the road balanced, or conservative? And if you're covering those, with good choices that are based off of a process, you're going to be protected under ERISA 404C. If you have questions on that, please let us know. We talk about communication a lot and education to participants. I've never seen a case where an organization got in trouble for too much communication or offering too much education. Typically, the more communication you have with your group, the better off from a fiduciary standpoint you're going to be. So the benefits, it provides employees with a more complete picture of the plan's provisions and investments, helps participants understand the plan and their retirement objectives, and it empowers them with the information tools they need to take control of their retirement. So not only does it help, I think, protect you as fiduciaries by making sure, hey, we're communicating, we're sending out education. We're trying to help educate our employee base while providing them with the ability to talk with an advisor. It's good for employees. And financial or health, it's very important. If your employees feel like they're in a good spot for retirement, they have a good understanding of where they at, that goes a long ways. That helps keep an employee happy and content, because we do know that financial related concerns are some of the biggest concerns that employees do have out there. So the more and more we can do to help that, the happier of an employee that we're going to have. And then let's just keep it simple. A lot of what we talked about can be, kind of scary, as you're talking about, fiduciary, civil, criminal liability as a fiduciary. Just make sure you understand your roles and your responsibility. Again, review and monitor your providers, and make sure that investment decisions are documented and that you're doing this. If all of a sudden you've skipped a couple of years, you should be looking at reviewing this. Again, making sure you've done a fee benchmark. If you're a fiduciary, making sure that, have you talked about fiduciary liability insurance with your insurance provider? Those are things that you can all do to help mitigate a lot of these risks that are out there. For example, we talk about fiduciary, liability insurance, but potentially how that can help is, let's just say that you had individuals who thought they were automatically enrolled, weren't automatically enrolled, and all of a sudden, it's years and years later, that fiduciary liability insurance could potentially help pay for the cost of, defense cost of something of that nature. So it's not always just about investments. And then communicate. The more you can communicate about, when you're eligible, communicating that you have access to talk to an advisor, that if you haven't signed up, that you still have the ability to sign up. The more and more you can communicate, the less chance employees or participants can come back and find fault in something that you've done. Again, communicating, over communicating, always a good thing. And then document, document, document. That's one of the biggest things of this is, as we talked, it's not always, was it the right decision? It was it documented, and was there a process in place to do this? So hopefully these topics that we talked about help you maybe understand what is our responsibility. Am I a fiduciary? Am I not a fiduciary? And these are all going to help improve the plan. All of these things that we've done, being more interactive, taking more care of the retirement plan, is going to help the organization, and it's going to help your employees. With that being said, if there's questions, please reach out right now. If not, my contact information, you can reach out to me at any point, and happy to have any conversations that you'd like to have related to 401k plans. So appreciate the time this morning.
And with that, we are going to open it up to questions. You can put in anything that you would like to ask John at this time into the question feature of GoToWebinar, and he can answer those questions for you. So our first question is, can the role of a trustee be effectively outsourced to a paid third party, such as a 401k retirement plan?
That's another one of those questions that has a little bit of gray area, because it can. And a lot of times they will take on as a trustee role, where maybe they can sign off on forms and things of that nature. And so that's totally fine. And we do see that to some extent happening. Now, at the end of the day, the responsibility to the organization is to still make sure that that trustee is acting in good faith, and that they're following the plan document the way it's to be performed. So yes, it can, But it's just like with a fiduciary 321 or 338, ultimately you've hired that organization to be the trustee, and there has to be some oversight of those things that are happening. So as long as you're, you know, meeting with that trustee and reviewing the things that have happened, I think that's completely okay. But just know that you can't just neglect or negate any risk or all risk when you do that.
Thanks, John. Anyone else have any questions at this time? All right, and just a reminder that we will include John's contact information when we send out the recording and copy of the slides. So if you do think of something after the webinar, you can certainly reach out to him. Thank you guys so much for joining us for today's webinar. Hope you have a wonderful rest of your day. And just a reminder to fill out that survey and leave us with some of your feedback. Thank you very much.